Hello and welcome to our lecture on voting and representation. I would like to start with a case called Shelby County, Alabama versus Holder. But before you can understand that case, you have to know a little bit about a case called South Carolina versus Katzenbach. That case was decided in 1966 and involved a challenge to the Voting Rights Act of 1965. In the Voting Rights Act, Congress had moved to stop discrimination against minorities by certain states with a history and tradition of discrimination in assigning voting rights, ensuring that minorities were registered to vote, and upholding the rights of minorities to vote. And part of the Voting Rights Act required that states with a history and tradition of discrimination submit any voting plans and changes to voting plans to the Department of Justice for pre-clearance. Basically, the Voting Rights Act stripped control of some states over their own voting apparatus. And the justification for doing this was that Congress was remediating the efforts of states to deal with racial discrimination in voting. And the Supreme Court eventually agreed. Now, Alabama was one of the states that was selected for this pre-clearance requirement. Other states included Alaska, Georgia, Louisiana, Mississippi. Uh, Excuse me, I think I said Alabama. South Carolina was one of the states that was selected for this pre-clearance. Others were Alabama, Alaska, Georgia, Louisiana, Mississippi, and Virginia, as well as some portions of other states, including North Carolina. But South Carolina, the entire state, was subjected to this pre-approval process to ensure that minorities were not being systematically deprived of the right to vote. And so South Carolina sues. And the court agrees with the federal government that the use of this pre-clearance requirement was necessary because the blight of racial discrimination in voting had affected the nation for so long that Congress could appropriately respond under the authority of the 15th Amendment by passing a very conservative enforceable statute, as the text says. The 15th Amendment Congress was given power under the 15th Amendment to remediate the efforts of states to supervise their own voting apparatus. I believe I said 14th early in the lecture. This is a 15th Amendment case. Okay, so for many, many years, from 1965 onward, South Carolina its voting apparatus was under the supervision of the Department of Justice. And in 2013, Shelby County, Alabama, sues the federal government and says our history of discrimination is over with. There is no evidence that it is necessary that we be supervised along with all of these other states. Some states had been subtracted and added. For example, Texas had been added to the list at various times. Georgia also remained on the list. Mississippi was also remained on the list. So the list had changed a little bit, and Shelby County says there's no longer this history of discrimination. The supervision should end. So the question is, does the Voting Rights Act's extraordinary measures, these pre-clearance measures, including its disparate treatment of the states, so some states are supervised and others aren't, does that continue to satisfy constitutional requirements? The court says no, it doesn't. By a 5-4 vote, they strike down that portion of the Voting Rights Act. And Chief Justice Roberts writes that racial disparity in 1965 was compelling evidence justifying the pre-clearance remedy and the coverage formula of Sections 4 and 5. There is no longer such disparity today. So the conditions that required it have gone away. I will note, actually, that this was a very limited decision. There was a lot of hand-wringing after this decision was made by the Supreme Court, that there would be states would be given free rein to just do whatever they wanted to and deprive minorities of the right to vote. That hasn't been the case, and in fact, the Department of Justice has filed a number of suits against states. In one instance, they filed suit against the state of Alaska for closing down polling booths in such a way that native populations had to travel great distances by boat to get to their polling booth, their polling location, so there've been other suits filed. So the the extent of the effect of this case, Shelby County case, is quite limited. Reynolds versus Sims would take us back to 1964, and this is a case that articulated the one person, one vote principle that's characterized the court's voting rights jurisprudence since then. And the question at issue in Reynolds was, is Alabama's apportionment arrangement a violation of the Equal Protection Clause of the 14th Amendment? Now, this has to do with setting up election districts and redistricting. Your text has an extended discussion of the Reynolds case and the circumstances that brought it about. Now, before Reynolds, the Supreme Court had heard two cases, one called Colgrove versus Green in 1946, and the other Baker versus Carr in 1962. In Colgrove, an individual sued they're saying that their voting districts, their congressional districts in Illinois, were malapportioned, and they said that this violated a certain portion of the Constitution called the Republican Government Clause. The Constitution says that the states are guaranteed a Republican form of government, and they contended that that failing to redistrict had violated this clause. The Supreme Court said, nope, we're not hearing this case. We don't have the authority to decide what that clause means. That's a political question, and we're not going to touch it. In Baker versus Carr, we get almost a carbon copy of Colgrove, but in this case, the individual doesn't bring the lawsuit about malapportionment under the Republican Government Clause. They bring it under the Equal Protection Clause of the 14th Amendment, saying that malapportionment is a violation of one's equal protection rights. The court says, yes, you can bring that case. And in Reynolds versus Sims, they actually address what malapportionment means and how it should be dealt with. So in Reynolds, Alabama had initially in 1901 had apportioned for the state legislature 106 slots for House members and 35 for senators. And over the years, the district populations had grown and fluctuated quite a bit, so that there were many districts that were a much greater population than others. For example, the case notes that the largest senatorial district of those 35 had a population 41 times that of the smallest. So you can see that's basically what I mean by malapportionment. A person voting for a senator in the most populous district, their vote counted 41 times less than the vote of a person in a district that was much more rural and had a much smaller population. So the question there is this malapportionment a violation of the Equal Protection Clause? Supreme Court says yes, with a majority opinion by Warren. Warren notes that representative government depends on proper representation, so that each person's vote would basically amount to the having the same effect on the number or the number of legislators in a legislative body, that they have an equal chance of electing and having their votes count toward the election of a legislator. So he says here, the representative government depends on proper representation so that a majority of the people can elect a majority of the representatives. Any scheme that undermines that basic principle is at odds with the guarantee of equal protection. In Miller versus Johnson, 1995, the court considers a Georgia redistricting plan that made race the primary consideration for constructing the district, the geographical district. And Georgia, under the supervision of the Department of Justice, constructed 3 legislative districts that were primarily African American. It was an attempt to concentrate the African American vote so that there would be representation for African Americans in the legislature. And white voters in those districts sued, saying that the emphasis on race as the primary factor for constructing a district violated the Equal Protection Clause of the 14th Amendment. The Supreme Court agreed with a majority opinion by Justice Kennedy. The court says that states cannot use race as the basis for constructing a voting district, and that it cannot be the primary reason for constructing a district. So racial concentration is also a violation, as much a violation of equal protection as conspiring to racially dilute a vote. Okay, and another case, Crawford versus Marion County Election Board. Question here was concerned the presenting of a requirement of a voter identification card, and whether doing so arbitrarily disenfranchises voters, in other words, deprives them of their voting right in violation of the 14th Amendment. So when a state requires a photo ID in order for someone to cast a vote, is this a violation of the 14th Amendment? Now, this is a very delicate question, or that delicate issue. I hear quite a bit people who have a lot of resources saying things like you have to present an ID to buy a gun or to buy liquor. Why shouldn't you be required to present an ID when you go to vote? Well, exercising your voting right is a lot different. It is, in due process terms, it is more fundamental than buying a beer, and I actually kind of find the comparison kind of offensive. But why is it that requiring people to have a voter ID, a photo ID, would arbitrarily disenfranchise voters? Well, studies tend to show that when you place that additional barrier on voting, in addition to all the other barriers that Americans have to accessing the polls and going to the polls, you actually tend to suppress the vote for a segment of the population, and that segment are the poor and African Americans and other minorities. Why is that? Well, it's sometimes very difficult for people to obtain necessary documents to get a photo ID from the state. In order to get a photo ID of any kind, you have to present a valid birth certificate, and oftentimes getting those certificates is quite difficult. In fact, Texas made it almost impossible for the children of illegal immigrants to obtain the necessary documents so that they could get the photo ID in order to vote. There have been other problems. There's a case recently in which the voter ID requirement, photo ID requirement in Texas was just recently struck down. So how does the court rule in Crawford? Does this law requiring a photo ID violate the 14th Amendment? The court says no. 6-3 says the law does not substantially or invidiously burden voters because of extensive measures the state took to ensure that it was easy and free for anyone to obtain a photo identification. And honestly, if that is the case, if it is easy for a state to ensure, or if a state actually takes measures to make sure that it is easy for someone to obtain a photo identification, then I think requiring a photo ID makes sense. But if you use it as a barrier to obtaining a registration for voting, then we have difficulties. Look very closely at the Citizens United case. This is also a vastly misunderstood case. The question there was, can government regulate corporate political speech through suppression and through disclaimer and disclosure requirements? So in other words, can the Federal Election Commission keep corporations from donating money and using money to endorse candidates? And the question, the court answered the question by saying, no, the government may not. The First Amendment protects the speech and the speaker and the ideas that flow from each, and there's no sufficient governmental interest for limiting the political speech of corporations in ways that it would not limit the speech of individuals. In response to this case, 2010, in response to this case, in 2012, the amount of money pouring into elections increased dramatically, but it didn't come from corporations. Corporations' donations increased slightly, but the large amount of money flowing into the coffers of political action committees and also campaigns largely came from individuals who were unaffected by Citizens United. So when you heard Bernie Sanders say things like, we need to overturn Citizens United to get money out of our elections, doing so, overturning Citizens United, would not have done it. Okay, hopefully at this point you have looked over the Bush versus Gore summary and you know a little bit about the case. The question there was whether the Florida Supreme Court violated the Equal Protection Clause by ordering this statewide manual recount and imposing a standard of voter intent on all electoral districts, all counties and precincts when evaluating what they called undervotes, recording of undervotes. Now, what is an undervote? We didn't talk about that in the summary. It basically has to do with the results of a CHAD, a little perforated piece that someone punches out when they want to record their vote, getting forced back up into the space and thus recording a no vote for president. Now, we know that it is highly unlikely that someone will go to the polls and vote for dog catcher and justice of the peace and county judge and not vote for president. It's much more likely that someone will vote for president and they'll vote for their senator, their representative, and governor, and not vote for those down ballot races. It's very unlikely that someone who votes for their representative or their senator or their governor doesn't vote in the presidential election. And yet that's what we saw in Florida, a lot of undervotes for president, a lot of people who recorded votes in other races, but their vote wasn't recorded for president because of the hanging chad. And so the Florida Supreme Court imposes this standard intent of the voter, and the question was whether that standard is so vague that it violates the Equal Protection Clause because not everyone's ballot is treated in precisely the same way. The court answers, of course, yes, the imposition of that standard does violate the Equal Protection Clause. They halt the recount and then they say, because there's only an hour and 59 minutes left before the drop dead date for recording the votes for the presidential election, the Florida Supreme Court does not have time to come up with a better, more precise standard. So we're just halting the recount altogether. At that point, Al Gore concedes the election to George W. Bush, and the court says The recount order was to determine the, quote, intent of the voter. This idea works in the abstract, but not well in reality. To make such a determination, we need clear rules. That is something the Florida Supreme Court failed to do, and since there is no time to fix it before the safe harbor deadline, the court halts the recount and thus gives the election, some people believe, to George W. Bush. Okay, thank you very much for your attention, and that is the end of our lecture on voting and representation.